Good morning, everyone. My name is Stephanie Spiers, and I'm Counsel of Program Development here at the Law Society. And it's my pleasure to welcome you this morning to our first ever 6-minute securities lawyer. I have a couple of announcements before I introduce our chair today. First of all, if you have a cell phone on you and you haven't already turned it off or set it to vibrate, please do so now. Secondly, there will be an opportunity for questions at the end of the program, and you might want to take notes for yourself. Also, you would have received in the materials a gray course evaluation form at the very beginning of the materials. Please take a moment at the end of the program to complete that and hand it in to us at the outside where you registered. If you do want to put your name, we will have a draw and there will be a prize for the winner. So we're encouraging you to fill those out because they help us with our future planning. That'd be greatly appreciated. Also, just so you know, we do videotape every single lecture in the lecture hall. So you're aware that either your voice or image may be captured on videotape. Finally, I would like to thank our chair, Brian Ludmer, and all the faculty for their extensive efforts in bringing this program together. Brian Ludmer is a partner in the business law group at Ogilvy Renault. His practice is focused in the areas of corporate and securities law, with an emphasis on mergers and acquisitions, merchant banking, venture capital, and private equity, real estate investment trusts, and technology companies. I do refer you to his biography for more details, and Brian will be introducing each of our speakers as they come up. At this point, I am pleased to turn the microphone over to Brian.
Thank you very much, Stephanie, and good morning, everybody. I don't know if you heard while Stephanie was speaking, but our little egg beater timer here did go off. And this is the ultimate challenge for a chair of a 6-minute program to keep everybody on schedule, because we do have 20 very highly qualified, very experienced speakers for you here today. We're actually going to, it's a bit of a misnomer, but that's how the series started. We're actually going to let them speak for 7 minutes before the timer goes off. We'll let them finish, maybe take one question for the most part. Hopefully most of the faculty will hang around and can take questions at the end. And then there'll be about 30 seconds while one person steps down and I introduce the next. That's the way the format works. So we're going to endeavor to stick to the schedule so that we get you out of here when we're supposed to. One announcement, Phil Anisman, our second speaker, unfortunately very, very recently had a death in the family. So literally being last minute, I stepped in, kind of pulled an all-nighter, and I'll be taking his spot. So without further ado, I would actually like to introduce Tom Graham. Tom has an accounting background, but is currently head of that part of the TSX that most of us as counsel to companies will deal with on an ongoing basis. Basically, his group runs the company manual. You have to go to them for all the approvals contemplated in the company manual, and his group is ultimately responsible for original listings as well. I'm certainly interested in hearing about the latest developments in our market structure in Canada, and I think the common theme you're going to hear from all of our speakers today is that the last 5 years or so has just resulted in an enormous amount of changes in the area of securities law. So the next time I hear a tax lawyer complain about how hard it is for them to keep up, I'll perhaps refer them to the binders and binders of materials that we have to deal with. So without further ado, I'd like to turn it over to Tom. And I'll just remind everybody again, because there's 20 speakers, if you could just follow along with your course evaluation form as it goes. And Tom, we'll set our timer here, and we'll see how that goes.
Thanks, Brian. My pleasure to be here on behalf of the Exchange today. I was going to start out with some, what I thought would, in the end, I thought it was questionable humor about the definition of a 6-minute lawyer and what a lawyer could or could not do in 6 minutes. So I thought better of it. I want to be invited back. This is a fantastic forum, so we look forward to participating in it, and I appreciate the invite. I guess, first of all, if we're talking about the corporate landscape, let's just start where we see ourselves fitting into the Canadian capital markets, and I'll use that time frame. 5 years has been a tremendous change within that time. We've gone from sort of the not-for-profit world, to the for-profit world, to being a consolidator of the exchanges in Canada through the over-the-counter market, CDNX, now TSX Venture, into the TSX Group, and now are stepping out into the public world as a public company, as we did in November 2002. So there's been lots of changes for us. Through that, our stakeholders have really remained the same, and I think it's allowed us to focus on our strengths, which we see as running a quality market, and we do see all those stakeholders as customers. And our vision is to be the leader in Canada for the capital markets. So that's where we see ourselves fitting in. And we've structured our business to reflect that. As I think most people know, we have the Venture Exchange and the Toronto Stock Exchange, which run the two listing groups, and I'll drill down into those in a little bit. We have our markets, which maintains the trading and the trading products for our customers. Data, which provides just a wealth of information to market participants. And finally, TSX Technologies, not finally, but TSX Technologies drives all those business units by having a reliable trading engine and the information systems we need. Finally, CanDeal is sort of our entry into the bond market. And currently, I should just point out, that's only government bonds and provincial bonds, and if you're interested in more information on that, candeal.ca, there's a full web page on that. I think this also highlights what we're not involved in. The Montreal Exchange continues to run the derivatives business. As we'll see, a lot of our sort of regulatory functions have been shifted away somewhat, the purely regulatory activities, so we can focus on purely the customer aspect. So going into listings for a moment, there has been some changes this year. I don't know if people have heard about the next market, but the idea is that we have three listings units now. One is the Toronto Stock Exchange, which is for the senior companies in Canada and abroad to list. The Venture Exchange is for the companies which are earlier stage companies, still developing, still growing, haven't met the tests for the TSX yet, but are learning how to be public companies. And finally, next is a place where sort of the fallen angels, if you will, or failed companies can go to regroup, recapitalize, and start something new again. So that was a new initiative in the past year. I do want to talk about the Toronto Stock Exchange because that is what I'm focused on. And I am new to the position. I've only been with the Toronto Stock Exchange for about 5 months. However, I was with the Venture Exchange and its predecessors for the last 5 years. The way we split things up in our group is we have three groups which service our listed issuers. One is client development, and basically they're focused on enhancing and developing the relationship with our issuers. One of the initiatives you might have read about recently is a showcase we currently have in Frankfurt with a number of our senior issuers. Barb Steinmetz is there today, along with members from our client development group. France Lafortune is the director of that group. Compliance and disclosure performs the function of monitoring companies' ongoing activities in the compliance and disclosure area. You may have read our recent publication of the study on corporate governance, and their work is day-to-day monitoring those activities. And finally, there's the Listed Issuer Services Group, which I'm in, and that's had a lot of changes over the last year, and in particular, starting January 1st, we are one group. Historically, it's been two groups. There was a group called Advisory Affairs, and there's a group called Original Listings. Going forward, again, our focus is on sort of listed issuers as customers, so we've combined those two groups. So now, when you have a listings manager, at the time of listing, that manager will continue with the company. Presumably, they've gained knowledge of the business that is useful going forward, and we hope is going to improve communication. I guess there'd be no discussion on the current landscape without some discussion of investor confidence. People even went so far as calling the new rules investor conference. They got tired of people trying to figure out what they're trying to get at, so let's just call it the rules investor conference put up with the commissions recently. It's key to our business, and mutually, I think it's key to everybody's business here, and we see it as very important. We are only one player in a.
Okay, there we go. It does work. But why don't you finish?
Okay, sorry. Anyways, this was going to be the point where I ask you to look into your neighbor's eyes deeply and say, I will do everything I can to help improve investor confidence, because I think we can all improve it as a group. 8 minutes is short, eh? 7 minutes. So really some takeaways for today's presentation. Streamlined services, I talked about that a little bit. The rule review update, that's currently out for public comment, what we hope is the last public comment. Those are due February 13th. The comments are due February 13th, and with any luck, we'll have a rollout by April 1st. That's 5, 6, and 7 of the company manual. It could have implications for you this year in your proxy season in terms of blanket approvals, which will basically no longer be relevant, and for stock option plans. So recommend everybody either call us or look at the draft policies. Corporate governance, commissions just put out their policy on it. We have to see, what holes are left and what role we're going to fill in corporate governance. We will maintain a presence in corporate governance either through education and awareness and rules if need be. Other observations, obviously the mining industry is very busy right now, and our client development group is working closely with them, and we want to do everything we can to make sure that companies around the world see the Toronto Stock Exchange as the global leader in mining, and I'd be happy to talk with people about that. If you're not on our database of advisors, please contact me. That's where we send out regular email blasts and really try and keep people informed. And in terms of what we can do for you, if you're working with companies and you want to talk to us, we have an open door policy, and that's really what we're trying to get across to people. So call us, call my colleagues, any of the managers in my group, or the business development group.
Thank you very much, Tom. There's so much to say on all of these issues that it really is difficult to confine the remarks. But the one takeaway that I think we can all take from Tom's remarks, notice how the listed companies are now clients, and notice as well how the TSX has gotten into other lines of business, and that's primarily as a result. It is now for-profit. There's a lot of movement and competition amongst the markets. Every day you see things in the paper like NASDAQ listing NYSE companies, so it's really quite vibrant, and I think we'll continue to see an evolution there. So I'm actually going to cut my time and restrict it to 6 minutes. We'll see how I can, that's okay, we'll see how I can pull that off. Okay, so basically, I'm very sorry personally for Phil, but also that you don't get the benefit of Phil's comments. Phil's involvement with the issue of federal versus provincial regulation of securities law, and also the current debate about a mixture of functions on the part of regulators, adjudication, enforcement, as well as passing regulations themselves, goes all the way back. He was the principal author of a 1979 study that the federal government put out called Proposals for Securities Market Law for Canada. So he really is the expert in this area, but you can take my remarks for what they are. A brief background: if you go to the Wise Persons Committee's website, and in the handouts that you are going to get on this point, you'll have their website there. Look at some of the comment letters. You'll see a recurrent theme of frustration with the multiplicity of regulators and regulations in securities law, even after 20 years of a tremendous amount of harmonization, mutual reliance, and crafting what the regulators like to call the virtual National Securities Commission. And there's tons of examples, the whole MRRS system for exemptions, for offerings, the harmonized prospectus rules, SEDI, CEDAR. actually the regulation of stock exchanges themselves and now the National Registration Database, and you'll hear about some of those from other speakers. Notwithstanding all that, there are complaints. There's still a perception about cost and time delays. There's still a perception of lack of consistency and uniformity. There's a concern that there's a lack of enforcement. Some statistics came out of the Wise Persons report that the SEC, itself under attack for not pursuing adequate enforcement, spends 29% of its budget on enforcement, and our major regulators 13 to 19%. So the hope is that by consolidating, and the estimates are, there's some competing studies, but the estimates are that about a third of the combined budgets could be saved. And if they take that and throw that at enforcement, we'll not only get greater efficiency, but greater perceived transparency in the markets. Now, if I then ask you, what does Canada have in common with Bosnia-Herzegovina, if I pronounce that properly, I don't think I'd get a response. But those are the only two of the 103 members of the International Organization of Securities Commissions that don't have a national regulator. So it just shows you where the trend is. Why is this issue still festering after Phil's report from 1979? Well, frankly, a lack of urgency on the part of the regulators. The CSA itself, Canadian Securities Administrators, is really a loose coalition of regulators up until very recently, without a permanent staff, without its own budget, without any direct accountability to the population themselves. Many of the virtual National Securities Commission initiatives themselves retained opt-out provisions. So we still do have this ongoing debate of regional differences based on perceived need, as compared to having a consistent body of rules across the country. Some of the provinces have been sidetracked on other issues. Some provinces are melding all their financial services regulators. Ontario is now dealing with the issue of enforcement versus standard setting in one regulator. There's some philosophical differences. Quebec, of course, has been adamant, they didn't even appoint anybody to the Wise Persons Committee, that they will not surrender this issue, which they view as central to their independent being. BC is, pardon the pun, out in left field with their own model of securities regulation. Now, the federal government hasn't been completely silent. There's some trial balloons out there that we're still, see, there you go, debating whether they're symbolic or not. They have some proposals to amend the CBCA, and there's a Senate committee report which, if they follow it, would see them completely jump into the securities field. In the handout, the other handout, what you'll have is a nice grid which takes you through the three principal proposals being debated today to deal with this issue of a uniform approach to securities regulation, or perhaps the feds entering the field. One is the passport system, which essentially, if you get blessed by one regulator, the other ones can't do anything to you, and you're free to offer or get an exemption. Then there's a Uniform Securities Act itself that is out for comment. That's an initiative of the CSA itself. And you could either build a federal regulatory platform on that or use the platform system itself. And then the third, probably the most controversial, is the actual recommendation of the Wise Persons Committee that the feds do enter and take over the field. But as of this morning, I just heard it on the news coming down here today, there's still a reticence, even though there are three opinions that the Wise Persons Committee got, including one from my firm, that constitutionally the feds can do it. They're not going to step in and just grab the field. They're going to work with the provinces, but they are going to turn up the heat at this point. So I'll just refer you to these materials that they will be distributing shortly if they haven't already, and we'll move on to our next speaker. Our next speaker is Paul Bourque. Paul actually has a background in criminal law enforcement and administration out in Alberta. He spent some time at the OSC as Director of Market Operations and is currently the Senior Vice President of Member Regulation of the IDA. And as such, Paul has been principally involved with some of the big initiatives coming out of the IDA. If you go back 5 years, the whole area of intermediary regulation has shifted markedly, and Paul's going to bring us up to date about the changes over the last while. Paul?
In 8 minutes. Thanks, Brian.
It goes fast.
There is a handout at the front which you can pick up at the coffee break. It's a contact list of SROs and their complaint and enforcement departments. Starting with a number of topics, the paper this morning, the passport system, you may have seen the Globe and Mail. It's an initiative of the CSA. Looks good for issuers, intermediaries, not as effective. Some of the problems that will continue. Cost of compliance, you still have to track all the different registration requirements for intermediaries in provinces where you don't have a head office but where you operate. And the system contemplates a review system where there's still an opt-out available as opposed to a notice system where it's simply giving notice and then moving forward. So that's a quick overview of the latest initiative of the CSA. Overview of SROs. Jurisdiction is based on contract, not legislation. That's a key point, a very important point. It arises from time to time in things like privacy legislation, where providing information to SROs for regulatory purposes is not required by law, and therefore we have to rely on consent. It's a very big issue right now as far as SRO compliance is concerned, and we're working on that with notices to the industry as to how they can comply and ensure we still get the information we need. A key distinction in SRO regulation between market regulators and member regulators. The IDA, the Mutual Fund Dealers Association, the Bourse de Montreal, all member regulators. The latest, the spin-off from the TSX, Market Regulation Services, Inc., and the Bourse are both market regulators. So that's a key distinction to keep in mind. The Industry Compensation Fund is sort of the fifth SRO. It has some oversight responsibility for financial compliance as it relates to the IDA and the Bourse de Montreal, and they run the industry-funded compensation fund for those SROs. The latest news there is that the MFDA is considering joining the Canadian Investor Protection Fund and coming under their auspices or developing their own fund. I think right now they seem to be moving in the direction of joining CIPF. Consolidation of member regulation is occurring or has occurred over the past 5 years. It's being consolidated in the IDA with the transfer of member regulatory responsibility from the Toronto Stock Exchange in 1997, from the Alberta and Vancouver Stock Exchanges in the year 2000, and there's a chart attached to show you the relative membership in the IDA. The Mutual Fund Dealers Association is one of the newer SROs, constituted in 1998, became more or less operational in 2001. They finished reviewing all their membership applications, so they have all their members in place now. They're in the process of conducting compliance reviews and taking complaints. The latest issue there, of course, is late trading and time trading. The MFDA and IDA both circulated surveys amongst our members to get more information on exactly what's going on and whether or not some of those practices are occurring in Canada. Market Regulation Services, Inc. is another new SRO, became operational in 2002. They're primarily responsible for enforcing compliance with universal market integrity rules. They look after the markets that they have contracts to regulate, the TSX, TSX Venture, Bloomberg, and CNQ. And they were the driving force behind the recent Insider Trading Task Force, which made recommendations to the CSA, which have adopted those recommendations and are in the process of implementing them. National Registration Database, a joint project of BC, Alberta, Ontario, and the IDA, up and running as of March 31st of this year, provides for electronic filing of applications, notices, and fees. Quebec is probably coming in at the end of this year. SRO discipline, a number of major enforcement actions taken by the IDA against firms, Rampart Securities, Thompson Kernahan, First Delta, all no longer with us. Major fine against, in the past 12 months, against BMO Nesbitt Burns failing to supervise, $500,000 fine for a broker in Alberta. In terms of complaints and reporting, the IDA implemented Policy 8, which requires the reporting of client complaints, internal investigations, civil claims, regulatory findings and sanctions and criminal charges of all our members. They are required to report them electronically on our web-based facility called ComSet. We've had about 2,000 complaints come in through ComSet. About 700 of those complaints have been turned into open files. Client compensation, very important aspect of the whole regulatory system. The IDA, along with the Canadian Bankers Association and the Mutual Fund Dealers Association, have created an ombudsman called the Ombudsman for Banking Services and Investments. The ombudsman looks after complaints involving amounts of up to $350,000. The ombudsman will make a non-binding recommendation to the firm for compensation if that's appropriate. The firm doesn't have to follow the recommendation, but if they don't, they will be outed. That will be published. And to date, all the firms have complied with the recommendation of the ombudsman. Thank you, Brian.
You don't have this. You got a minute, so.
One last thing, policy, very important part of SRO activity. All the SROs have policy departments, including the IDA. We have a rule book as big as anybody's, probably bigger, and one of our most recent initiatives has been Policy 11 relating to analyst standards. The one key difference there to note between the approach of the NASD and the NYSE is that Policy 11 applies to debt market research as well as equity research, and to date that is not the case in the United States, but I suspect it will go that way within the next year. Thanks, Brian.
Thank you, Paul. I'll tell you, it is quite a shock when that timer goes off. Our next speaker is someone that I had extensive dealings with over the phone, always, when she was at the OSC, because Pam Hughes is a partner currently at Blake's, was the one person to go to if you had any question about anything international at all. And Blake's very fortunate to have her, and I'm sure she had a large role in the policy reformulation project that they were working on with the OSC. Pam's practice obviously then focuses on international transactions. She has an extensive background. She was Canada's negotiator for MJDS, and I'm sure she'll have some very insightful comments on current international securities issues. And with that, Pam.
Well, I decided to break this up into a number of topics, so you won't even notice when the buzzer goes off that I didn't finish. I thought I'd discuss the implementation of Sarbanes-Oxley in 2002 in the States, cross-border public offerings, foreign issuer continuous disclosure, U.S. GAAP by Canadian companies, and then a bit of a conclusion. But obviously, there's been so much press about Sarbanes-Oxley. It was response to a crisis of investor confidence, the Enron and WorldCom scandals and so on. And it exposed deficiencies in corporate governance. And in the US, there's a sweeping reform of CEO and CFO responsibility, the disclosure, the structure of audit committees, auditor oversight, criminal and civil liabilities, and so on. It's interesting to note that there's no general exemption for foreign companies, not even companies like Canadian companies that are eligible to use the multi-jurisdictional system and file a Canadian form of prospectuses in the States and Canadian form of continuous disclosure documents. So it's interesting to think about what the impact has been in Canada on Canadian interlisted issuers, Canadian counsel, Canadian regulators. For interlisted issuers, it's certainly meant a more complex regulatory structure so that they need to comply with the Sarbanes-Oxley requirements, the certifications, the structure of the audit committee, and so on. And also for, it's interesting to think about what the impact is as well on for NYSE and NASDAQ. Listed quoted Canadian companies. Although there is a foreign issuer exemption in the NYSE rules and NASDAQ, my experience is most Canadian companies choose not to use that exemption, but rather to comply with the requirements, the corporate governance rules that came out in November 2003. And in Canada, you can see the Canadian regulators there's been a debate about what the response should be in Canada to the Sarbanes-Oxley changes. The CSA just published on Friday corporate governance guidelines, a policy plus a disclosure rule relating to best practices in corporate governance. So that was the former TSX corporate governance guidelines. And it's interesting to note that they're not, unlike the NYSE corporate governance requirements, not mandatory requirements, but best practices. So what does that mean for this interlisted company? There are some differences, some extra. If you comply fully with the Canadian best practices plus SOX plus the New York Stock Exchange, you'll have Canadian companies subject to sort of a higher standard. So that's interesting. Certainly produces a complex landscape for Canadian counsel. Many of those Canadian interlisted issuers are going to look to their U.S. counsel for corporate governance advice, and then I guess the Canadian counsel for some of these top-up requirements. Turning now to cross-border public offerings, I thought I'd just sort of comment on a couple of transactions. I'd been in some of the trends that I've seen that certainly it's been interesting to see more over the last little while some changes in the underwriting syndicate structure where it used to be, going back a number of years that there would be for a Canadian issuer doing a cross-border offering a separate Canadian underwriting agreement and syndicate. Then you saw the structure of one underwriting agreement, but the Canadian dealers would be signatories to the underwriting agreement. And then the number I've worked on recently, it's just U.S. dealers that are signatories to the underwriting agreement. An example of that is a Nexon debt deal that was done, I think it was September, November. So you'd have the U.S. affiliate of the Canadian bank-owned dealer be the one that's the party to the underwriting agreement. So that sort of poses an interesting issue in terms of the requirements of securities law that says that the underwriters that are a contractual relationship with the issuer are the ones that have to sign the underwriting certificate. So what do you do with that when there aren't any IDA member firms that are in a contractual relationship with the issuer? And so if you look at a number of them, they'll end up having the Canadian affiliate of the signatory to the underwriting agreement be the one that signs the certificate. In a number of these offerings, there's not, even though it's a prospectus in Canada and the States, there isn't very much sold in Canada. I think partly that turns on sort of the U.S. Dealers keeping the allocations at home. Several that I worked on recently, one for a Canadian issuer and one for a U.S. issuer, that wasn't, the prospectus in Canada wasn't filed in Quebec. And because of the timing concerns and the cost of translation, I thought that was interesting. I raised that at our securities group meeting last week, and a number of the other securities lawyers at Blake's commented that they'd worked on several offerings, public deals that hadn't been filed in Quebec either. So I thought that was kind of interesting. Foreign issuer, I really got to speed through this. Foreign issuer continuous disclosure. That's the rule that the OSC published December 19th in final form, and it permits foreign issuers, SEC registrants, whether foreign or U.S., to use their SEC form of continuous disclosure documents, and then other foreign issuers that aren't SEC registrants to use their home country documents without reconciliation or anything, as long as 10% or less of the shareholders are in Canada. So that's sort of it's interesting to see the difference because of the smaller market in Canada. Canadian regulators can't say, well, comply with Canadian requirements no matter where you are, like the contrast Sarbanes-Oxley, where they say foreign issuers, everybody has to comply with the U.S. Regulation, which is understandable. So I think, so in summation, I think that certainly securities regulation in Canada is becoming increasingly complex. Anytime a new rule comes out, you print out a whomp of paper from the from the website, and then when you add in, it isn't as clear as it was in 1991 with MJDS and over the sort of the 10 or 12-year period, the Canadian issuers could comply with Canadian requirements. Now you've got this overlay of the US requirements, and increasingly this CSA trying to play catch up, recognize other countries' regulation. So it'll be very interesting over the next several years to see how all that shakes out.
Thank you very much, Pam. It's always a pleasure to get that kind of insight. Our next speaker is not a lawyer, but was pleased to assist me in structuring this program because our next paper is on the latest financial disclosure issues. Elliott Jacobson is a partner in Minson Partners. He has a cross-border practice, does practice before the SEC as well. His firm is recognized for that purpose. Elliott's a very frequent speaker at conferences dealing with securities disclosure, financial matters. I've spoken with him at quite a few events. There's always takeaways when Elliott's speaking. So he also wins the prize at this conference for the thickest material, and we have a special gift for Elliott for that. So Elliott, without further ado.
Thanks very much, Brian. I understand that the sum and substance of what Brian said, not all of which is true, but whatever, will be passed out at the break. I wondered if, when there was no resume in the binder, that was some sort of professional, institutional comment, but I guess not. As Brian said, there's a lot of takeaways, and I wanted to provide to you a lot more information on this area that can be imparted in 6 or 8 minutes, even by me speaking very quickly. I assure you I'm not going to read the whole 200 pages. What I've designed, or my thoughts, and it's in the hard copy of my commentary, is to focus on the things that I think a general practice lawyer would have that would have some securities practice. Also lawyers who may not be securities experts themselves, like the faculty, like the speakers, who would be on audit committees, on boards, and be involved in some of these issues. I'll draw your attention to what looks like a PowerPoint presentation, and in fact is in your material. It's not going to be repeated. That's one of the presentations I have done on the subject, and it covers a lot of the areas that you may want to be aware of in dealing with your clients, whether they're Canadian public issuers, US public issuers, or companies perhaps considering going public. It was at a conference that, in fact, Brian and I spoke at together, and it covers a lot of the things that accountants were concerned about. So guaranteed to keep you up at night. There's also a document from the Securities and Exchange Commission which covers what we accountants, and I think if you're writing management discussion analysis or advising on that, better get to know about, called non-GAAP financial measures. In that vein, there's also relatively hot off the press, a Canadian Securities Administrator staff notice on the same subject. And those are the things that when you're writing MD&A, you'd better be aware of, because companies have in the past misused things like core earnings, pro forma earnings, earnings before bad stuff, earnings before expenses, as measures to mask or explain, depending on your point of view, results that may not be so wonderful under boring old generally accepted accounting principles. Another matter is the relationship, and there's material about that, between auditors and the company. And this is something that lawyers will be involved, I think, in monitoring, because you're going to be on audit committees, you're going to be advising companies. And there is a list of there's information both in Canada and the United States of services and involvements that auditors can no longer have with their clients, if they're publicly listed clients. I've also provided not only the SEC material, which you'll see is written in a particular style, also some material that has been circulated and released to all Canadian chartered accountants on the same subject on our beefed up independence rules. The important message, and I'll deal with some of the more detail a little bit in the next couple of minutes, audit committees are in charge of the auditor-company relationship. As I say to many of my clients, the audit committee brings adult supervision to that relationship. And the goal, because of what happened in Enron, now perhaps, but we're not sure yet, in Hollinger, things like that, the auditors and companies get very close. And I'll be frank with you. Someone says, who's your client? Most auditors would say, it's the company, it's the management, not necessarily the shareholders represented by the directors. Even though Our audit opinion is addressed to shareholders. So the audit committee has been interposed, in my opinion, back where it was to begin with, and that's where it should have been. In the relationship, you're a sounding board, you're also supervising the flow of highly lucrative non-audit services that are now being, in addition to being limited, they're under your purview. In some financial statement matters, there's the issue that you'll hear accountants talk a lot about: special purpose entities, variable interest entities, or variably interested entities. These are some new accounting standards. Some of the material is attached, which touches on and covers these entities that, for example, Enron, that's one of the most well-known one, hived off assets, liabilities, cost streams rather than revenue streams away from their balance sheet and away from their financial statements, and by the letter of the accounting law, got rid of bad results. The sum and substance of this rule, and I'm not going to take you through an accounting version of it, if the sponsoring company, the one who sets this thing up, is exposed to loss beyond its own investment, particularly disproportionate to its investment, has rights to residual return, or anything else under which the arrangement is hardwired not to protect the arranging company, in this case an Enron or people like that, then you have to consolidate. In other words, can't hide. The improvement is gone. Come clean with what your off-balance sheet with your special purpose entities. It does not, and for people who deal in financial services, it does not deal with and does not catch companies or banks that will hive off into special entities like their Visa receivables and things like that. Those typically are structured in a way legitimately to move the whole thing away. But there's much more literature written than this, but essentially, if you're on the hook one way or the other, consolidate. And that's something that I think audit committee should be asking the company, asking the auditors. What have you done about this? Do you have any? My PowerPoint that's attached has some slides on that subject. I mentioned the non-GAAP financial measures. If you're writing MD&A, there's limitations on what you can refer to in explaining or discussing the company's earnings and why they're not so wonderful.
You've got a minute.
Okay, under GAAP. Two things very quickly. Auditor independence. We talked about that. There's non-audit services that are no longer provided. The audit committee has to monitor that, as well as cover the issues that are allowed, the services that are allowed. The U.S. is very simple. Don't do it. In Canada, we have a principles-based system. There are senior regulators who I've spoken to on the subject who believe that, unfortunately, it may not be as rigorous a limitation as it was originally designed, but time will tell. And the influence of the U.S. markets and the U.S. rules is pervasive. And there are some limitations. Last point, beware of changes to the CICA rules for offerings. Two big changes that, talking to a fairly experienced securities lawyer who was caught out on a filing. One is consent letters now belong in your filing. This is part of a CICA new standard issued in November of 2003 on auditor involvement with offering memoranda or offering documents, which is the tip. See, I'm not a good lawyer. The tip is offering memoranda for a company that used to be exempt from auditor involvement are now caught. That's caught a number of accountants by surprise, caught a number of issuers by surprise, caught a number of lawyers by surprise. And don't look to the securities regulators to say, well, gee, all of a sudden the costs for these junior issuers are going up. The CICA has made that rule. And it surprised me when I first read it a little while ago saying, oh my God, exempt documents that didn't involve auditors' consent, comfort, various things are now caught. Generally, offering memorandums that qualify debt under private placement. And that's it. And you can read the 200 pages at your leisure, or not.
Thank you, Elliott.
Okay.
Good to see you. Thanks. Okay. As you may notice from the agenda today, we are really covering an entire slice of securities law. We're going very broad. We're covering almost every chapter of securities law. If you were to go to the online Alboini service, you would see we're almost covering everything, and of course that limits how deep we can get, and that's why your speakers are forever running out of time. Our next speaker is going to tackle the area of financial intermediaries, and there's a tremendous paper that that you'll all get the opportunity to go through afterward. Robert Black is a partner at Borden Ladner Gervais. He has experience in the corporate finance branch of the OSC, and as well at the Toronto Stock Exchange, as well spent some time with an intermediary, Merrill Lynch. So I'm sure he'll have some great comments for us to take away. And Robert? See if I can squeeze in an extra minute for you.
Okay. Thanks, Brian. Good morning, everyone. My topic is an update on the regulation of financial intermediaries, as Brian mentioned. And dealers and advisors have had to keep up with a wide variety of developments in the past few years. I'll just touch on a few of them in the time allotted by the yellow timer this morning. The first area I'd like to talk about is the increase in OSC enforcement activity in recent years. There have been several high-profile cases in the last few years. I'll talk about a couple of specific points from some of them as they affect registrants. The first case I want to talk about is the YBM decision. It has significant implications, of course, on several securities and corporate law topics, but in the area of dealer regulation, it provides a good discussion and summary of the OSC's views of the role of underwriters in the due diligence process in an offering. The decision reiterates that an underwriter must challenge the disclosure that the issuer proposes to make, and therefore can't automatically rely on the information that it's given by the issuer, by directors, officers, and indeed the issuer's counsel. The OSC stated that while the underwriter is not the guarantor of full, true, and plain disclosure, it certainly is a gatekeeper. The decision also discusses the relationship between co-lead underwriters, which was a central issue in the due diligence process in the YBM offering. The OSC stated that in principle, there was no reason why one member of the underwriting syndicate cannot rely or should not rely on another member, but where a co-lead underwriter, quote, falls down in the conduct of its due diligence, the other co-lead may have to bear the risk of that reliance. Let me also talk about a few aspects of the Dennini decision, where the Yorkton Securities head trader was given a quite harsh punishment by the OSC. That decision has been the subject of much debate and controversy for a number of reasons. One aspect is its discussion of the relationship between the corporate finance and trading departments of a dealer. And the OSC went into some detail of this, and the decision acknowledged that conversations do take place between corporate finance professionals and traders, but it is difficult to pinpoint from the decision where a dealer should draw the line in imposing trading restrictions on its traders and trading department. For example, there is discussion in the decision that seems to suggest that even the most general and preliminary discussion about the potential market reaction to a future financing by an issuer with no discussion of potential terms should result in the dealer imposing trading restrictions on that trader who is involved in that kind of very preliminary conversation. And those aspects of the OSC decision make a dealer's procedures for handling confidential material information that much more difficult to manage. Another aspect of the Dennini decision that sparked a great deal of debate was the punishment given to him, a 15-year registration suspension, effectively a lifetime ban. This was somewhat chilling to individual registrants employed in the capital markets because Dennini had not settled the case. He had insisted on going to a hearing, which was his right to do, but in the OSC's words, quote, Dennini was not a credible witness. He has been unrepentant and unwilling to acknowledge that his conduct was unbecoming a registrant and contrary to the public interest, end quote. The contrast is striking with the sanctions imposed on Scott Patterson, the Yorkton CEO, a 2-year ban, pursuant to Patterson's own settlement agreement with the Commission. Now, the divisional court had some pointed words in the decision it released last year regarding its views of the punishment. The court noted the reference in the OSC decision that Dennini was unrepentant, but went on to say that an accused not pleading guilty is not and should not be subject to increased penalties simply because they have chosen to defend themselves. Among some other statements, the court also noted that there was an unreasonable disparity between the suspensions given to Patterson and Denneny. Perhaps most pointedly, the court observed that the penalty imposed on Denneny does not stand up to a somewhat probing analysis, was the phrase. So the court cut back Denneny's suspension to 4 years. For advisors, the Brian Costello decision is very important for its discussion of what constitutes advising. It also deals with advisor conflicts of interest. The next speaker, Pat Koval, is going to talk about that in more detail. The other high-profile regulatory proceeding that I will briefly mention is the Market Regulation Services case against Credit Suisse First Boston Canada. This is in many ways a test case of the RS ability to enforce the universal market integrity rules that now govern equity trading in Canada. RS made some very caustic statements in its statement of allegations when it launched the case. The hearing commenced last Friday for 1 day. It's going to reconvene at the end of this week. Initially, there are some motions for the panel, but what will clearly be at issue in the case is the extent of the authority that RS has to impose penalties on investment dealers in these circumstances. Let me also briefly mention a few other developments. There's now an electronic national registration database that contains registration information for dealers, advisors, and individuals who are registered in Canada. It can be used for filing submissions, mainly for individuals, in the form of a single electronic filing rather than multiple paper filings in each jurisdiction. All of the provinces and territories and the IDA participate in this, except for Quebec. Please go ahead. But Quebec has indicated that it's developing plans to become a participant. As Paul Bourque mentioned, there's also a major proposal that was released on January 9th for a proposed national registration system that would allow dealer and individual registration applications to be made to a single principal jurisdiction. That is a big step forward in the harmonization of the national registration process. That proposal is out for comment until the end of March. And I see that my time's up, and thank you for your attention.
Thanks very much, Robert. And again, I'd really refer you to his paper, which is excellent. Our next speaker, Pat Koval, is a senior securities practitioner with Tories, has been involved in countless significant transactions. I've dealt with her on a couple. She's really a tremendous practitioner. Pat currently teaches a course on takeover bids and proxy contests at U of T Law School, and is actually going to tackle an area unrelated to that. She's going to tackle something that you see in the news all the time: financial planners. Just what are they? How are they regulated? And does anybody own that phrase? Because it's something for the consumer that they're probably going to interact with securities law more often than any other topic we're going to hear today. Pat?
Thanks, Brian. Well, yes, as Brian has just said, there's little doubt that the whole area of the regulation of those who provide financial advice to individuals, and particularly financial planning advice to individuals, that this area is now and has been in recent years probably one of the most controversial and sensitive in terms of the search for the right balance between investor protection and the cost of regulatory compliance. The question of what financial planning actually is, what the proficiency requirements should be for those who practice it, and how those individuals should be compensated, I should say firms or individuals should be compensated, have spawned what I can only describe as years of debate between insurance regulators and securities regulators, insurance councils and life insurance agents, trade associations representing advisors such as the Canadian Institute of Financial Planners, and more recently an organization called Advocates, and self-regulatory and other securities and insurance regulatory organizations, including the litany is exactly what you'd expect: the IDA, IFIC, the Canadian Association of Insurance and Financial Advisors, otherwise known as CAFA, and the CBA. So having said that, in 6 minutes or more, what's now, what's new, and what's coming? In other words, what do lawyers need to know? I want to start first with the Costello decision, which was just referred to a few minutes ago, by way of a two-seconder background. What we all do know right now, of course, is that all of our provincial securities laws, including our own act, in particular Section 25 of our own act, require any person who acts as an advisor, a defined term, to be registered as such unless there is a statutory or regulatory exemption available. The act defines, or at least our act defines advisor, as one who engages in or holds himself out as engaging in the business of advising others as to investing in or buying or selling securities. Sounds straightforward enough. But in November 2002, a three-person panel of the OSC handed down a decision in a fairly difficult factual matter concerning a gentleman named Brian Costello. Many of you probably were familiar with Mr. Costello from his previous activities. I'm not going to cover the facts in detail because they are extensive, but suffice it to say that Mr. Costello was prominent on the seminar circuit. He gave seminars about investments and individuals. He distributed and published newsletters, and these were not newsletters of the sort that would qualify for the general newspaper exemption, which is already in the statute, because they weren't newsletters that were distributed to people who were simply subscribing for them. He also maintained a website, and he was a prominent radio speaker and had a regular radio show. And all of these activities basically involved talking about investments, securities, and individuals. The Commission, after scrutinizing what in fact were years of conduct, found that Mr. Costello's activities violated in the Act in the sense that Mr. Costello was not registered as an advisor. And they imposed quite significant penalties in this context. In terms of what the lessons or the nuggets of that case are, there are a few things. First of all, the panel said that the intention of the Act is to define the term advisor broadly, and by implication, the exemption should be strictly read. Secondly, the Commission said that simply providing financial information on securities does not constitute the giving advice, but providing an opinion on what they described as the wisdom or value or desirability of investing in specific securities does constitute giving advice. Moving to the actual definition, which has the concept of engaging in the business of, the Commission said that if one offers advice in a manner that reflects a business purpose, then that is sufficient to bring that individual within the definition of advisor, hence requiring registration. One of the more interesting aspects of the decisions, and there were two, one on the facts and then one on penalties, was what the Commission had to say on seminars, because that's an area that is frequently contentious. In this context, the Commission was satisfied that what Mr. Costello was doing at his seminars was not educational per se. Hence, he couldn't avail himself of the exemption for teachers. And what they had to say about the seminar conduct is instructive, because it's going to help govern anyone who's looking at this whole issue of whether giving a seminar is crossing the line into the area of acting as an advisor. The Commission looked at those seminars as a whole and said the clear purpose of those seminars was to generate leads. That basically was the business connection. And they highlighted some specific indicia with respect to those seminars which had influenced their decision. First of all, the use of hyperbole. Mr. Costello had referred to certain investments as the best he'd ever seen, for example. He did not discuss risk. He encouraged leverage. And he, to their minds at least, excessively focused on tax-advantaged investments, highlighting the benefits of the tax advantage, but without actually talking about the investment in the context of the overall investment sphere. So the teachings from this are instructive, again, for those of you who are advising people who are on the educational circuit. Lastly, the Commission was clearly offended by the fact that Mr. Costello had failed to disclose at any time the fact that he was, in effect, getting financial compensation from the issuers of the securities that he was mentioning in his various public media. And the Commission went on record to say that although the conflict of interest provisions, which is Section 40 of our Act, only apply to disclosure of financial or other interest on the part of a registered advisor, the Commission said if the Act should be amended to require that type of disclosure from anyone, even if they are technically exempt from registration. So quick to cover over the other elements that are important to be aware of. Quebec has a comprehensive regime. BC has a regime that governs policy planning for proficiency requirements. Ontario is now asking interested commentators to comment on the fair dealing model, and I invite you to take a look at the OSC's website. It basically it proposes a radical new model which focuses on the selling of advice in one of three categories, either self-managed, advisory, or managed for you. Not clear whether that is going to come into force. A lot of controversy about it. Take a look at it. And be aware that in terms of controversy, there's going to be a great deal of advocacy in this area. Groups like Advocates, which is now basically comprising most of the financial planning community, are going to be active advocates in the area of regulation, and we can expect to see them popping up in the regulatory context and acting as active advocates for the financial planning community.
Thank you very much, Pat. One thing that had actually occurred to me, and this actually goes back to something that Robert Black was speaking to, if you think about the parallels between the Martha Stewart investigation, where they're actually prosecuting her for interfering with the investigation, in effect lying during the course of their investigation rather than insider trading itself, it has some parallels with the regulators perhaps being overly harsh on those who actually seek to defend themselves instead of settling. Our next speaker is Mihkel Voore, who's a partner at Steinberg Elliott and co-chair of their firm's securities law group. Mihkel's a very experienced practitioner, but to me, Mihkel Voore is shareholders meetings, because I've had his book on my shelf from when it first came out, and that's where I always turn. That being said, I'm not going to have Mihkel speak to you on shareholders meetings, because that would be too easy. He's going to speak to us on the substantial changes in the area of prospectuses, long form, short form, that have taken place over the last 5 years and led to a uniform standard for what goes into a prospectus now. Mihkel?
Thank you very much, Brian. I'm going to actually try to focus my remarks a little bit more to a more recent period of time. The past 12 months, while they've been witness to a regulatory landscape that appeared at times in turmoil on a number of fronts, were relatively quiet when it came to prospectus rules. The basic regulatory regime established at the end of 2000 has experienced relatively little subsequent change. In its April 2002 staff notice, the CSA indicated that they were reviewing the prospectus regime in Canada with a view to enhancing harmonization and simplification, while the short form, shelf, and post-receipt pricing prospectus regimes were and continue to be governed by national instruments, which has tended to make our lives easier in respect of those more short form documents, and they all came into effect December 31, 2000. The long form prospectus regime had not, as of April 2002, and still has not achieved uniformity, although the OSC's Local Rule 41501 and other Ontario requirements have effectively been duplicated across country so that issuers in all jurisdictions can make use of the Ontario rules. Certain jurisdictions still retain in effect their predecessor long-form prospectus regimes, while the CSA had promised clarifying and technical amendments by spring of 2003 to all of the respective prospectus regimes to correct and address issues identified since their introduction. These have yet to see the light of day. In the absence of significant specific recent developments on the prospectus regulatory front, however, there are a number of outstanding wide-ranging proposals which may potentially result over time in change in prospectus offerings themselves. The CSA has for some time been pursuing initiatives that would harmonize and reinforce rules for secondary market disclosure. In January 2000, they published for comment their concept proposal for integrated disclosure system, which was intended, among other things, to provide investors with more comprehensive and timely continuous disclosure. More recently, in December of last year, the CSA published for comment consultation drafts of a Uniform Securities Act as part of their Uniform Securities legislation project. The CSA intend that the drafting of the uniform securities legislation would be flexible enough to accommodate a movement to an integrated disclosure system over time. Under such a system, a reporting issuer could make a public offering without filing and clearing a prospectus, provided that its continuous disclosure record was current. The issuer would simply file an alternative offering document disclosing the offering terms. Part 4 of the USA, or Uniform Securities Act, which was proposed in December of last year, continues to provide for core prospectus requirements through the prohibition of any securities distribution in the absence of a prospectus or an exemption from the prospectus requirement. It also does provide, as expected, for the flexibility to accommodate alternative offering structures, such as the CSA's proposed integrated disclosure system, and even the continuous market access system, which has been floated by the BC Securities Commission. The Uniform Securities Act proposal includes the current requirement that the prospectus provide full, true, and plain disclosure of all material facts, as well as general provisions relating to the filing of prospectuses and the issuance of receipts. It's contemplated that, consistent with the platform nature of the USA, and when you look at the Uniform Securities Act proposal, it is skeletal in the extreme, as well as what I would say is prevailing regulatory practice. Most prospectus requirements will ultimately end up being located in the specific rules. The CSA have also indicated their intention to conform to a greater degree the continuous disclosure obligations of reporting issuers and the applicable prospectus requirements. On December the 19th, the very same week as the USA came out, the CSA published notice of National Instrument 51102 with regard to continuous disclosure obligations. Form 51102F4, the business acquisition report, which, while new on the continuous disclosure front, is intended to provide the secondary market with financial information similar to that provided since 2000 in prospectuses in respect of so-called significant acquisitions. I would point out that the thresholds in the significance tests proposed in 51102 differ somewhat from those in the prospectus rules, and the CSA have stated that they intend to reconsider the significant acquisition requirements in prospectuses in light of changes to 51102. The CSA continues in all of the documents that I've mentioned, as well as a number of others, to tell the market that they're carrying out an ongoing general review of long and short form prospectus regimes. However, that has yet to bear fruit. Together with the coming into force of 51102, which will occur to most effects, I think at the end of March of this year, will be that of National Instrument 52107, which deals with acceptable accounting principles, auditing standards, and reporting currency, which specifies which issuers can utilize accounting principles and auditing standards other than Canadian GAAP and GAS. For instance, SEC issuers, as defined, will be permitted to prepare financial statements in accordance with U.S. GAAP with some transitional requirements. And then, as has been mentioned a couple of times before, there is the new CICA requirement with regard to auditor consent, which needs to appear in prospectuses. Giving a very quick overview of offerings and structures over the past year, I think it's safe to say that most activity was, or I shouldn't say most activity was focused on, but there was a great deal of activity on the income trust offering front and structured product front, some of which will be dealt with by Jenny Chu Steinberg in her remarks. But it was also a relatively busy time on the debt capital and equity capital side, which was nice to see an actual return to more conventional offerings from past years, which had really been dominated by income trusts. A number of issuers continued to make use of the MJDS system to establish cross-border debt shelves using their Canadian documents and then offering notes or bonds into the U.S. capital markets. People continued to make use of the Exxon Capital or AB type of exchange offers under MJDS. We also saw continuing to flourish Canadian financing subsidiaries of U.S. parents doing guaranteed medium-term notes in the Canadian market using largely their U.S. documents. In Canada, another significant development during the last year that I was involved with personally was the utilization of a shelf prospectus to create the so-called CARS and PARS program, which now permits prospectus qualified stripping of corporate debt, which added to the liquidity in the corporate debt markets. I think my last comment will be with regard to an interesting and still, I'd say, developing evolution of the last several years in the utilization by issuers of so-called universal or unallocated shelf prospectuses. For an example, you could look at the Hudson's Bay prospectus, which provides that Hudson's Bay can from time to time take down from the shelf debt securities, preferred and common shares, warrants to purchase equity or debt securities and share purchase contracts, and in fact share purchase or equity units. So it's a complete menu of securities which Hudson's Bay may from time to time issue. A number of other issuers do have unallocated shelves in place, though relatively few share offerings have been done to date. Newmont Mining and Manulife were significant examples of that type of deal this year. Thank you.
Thank you very much, Michael. Well, that was an extremely thorough presentation on what you could see was as well a very active area. We're going to take a break now. Our schedule, which of course is very strict, has us starting again, so the speaker has to start at 10, sorry, let me just check. At 10:34, the next speaker is starting. So if I can ask you to try and get seated by 10:32, and I'm going to subject you to the same timer. It's going to go off, and I need everybody sitting here. Thank you. It's vicious. It goes like you just go, it's impossible.
Tough.
Isn't that something?
Brian, nice to meet you.
Well, you can tell the litigators because they're way more prepared than the solicitor types. But it was great. Right.